Chapter 21. Criteria of Domicil, residence and lapse of time. SS 375. Presence at a place prima facie evidence of domicile there. When it becomes necessary to consider whether or not a person was domiciled at a given place, the most usual and obvious fact which meets is his personal presence. If we know nothing of a man save that at a given time he was at a particular place, his circumstances and antecedents being wholly unknown, and it is necessary to determine, for some purpose or other, where he was then domiciled, we cannot but conclude that he was domiciled where he was found. Lord Thurlow, in Bruce v. Bruce, said, "A person as being at a place is prima facie evidence that he is domiciled at that place, and it lies on those who say otherwise to rebut that evidence." Lord Loughborough used similar language in Bent v. Johnstone. The actual place where he is prima facie to a great many given purposes his domicile, and, apparently using residence in the sense of mere physical presence, Sir John Nishaw remarks, in Stanley v. Burns, prima facie, he is domiciled where he is resident. SS 376. Such prima facie subject to rebuttal, but it is apparent that this is the merest prima facies, and is not only susceptible of explanation, but is easily destroyed. Lord Thurlow adds to his remarks above quoted, it may be rebutted, no doubt, a person traveling on a visit, he may be there for some time on account of his health or business. A soldier may be ordered to Flanders and be detained at one place there for many months, the case of ambassadors, etc. And Lord Loughborough adds to his remarks above given, you encounter that, if you show it as either constrained, or from the necessity of his affairs, or transitory, that he is a sojourner, and you take from it all character of permanence. But in the case which we have supposed, it is not even necessary to explain the character or intention of the presence, if it can but be shown that the person whose domicile is in question was formerly domiciled elsewhere. In event of such proof, the presumption of the continuance of such domicile would apply, and wholly destroy the effect of the bald fact of bodily presence elsewhere. The principle seems to have been so understood in Bradley v. Lowery, where Johnston, ch. after citing the remarks of Lords Thurlow and Loughborough and Sir John Nishaw, said, that is to say, if we had never been apprised that the testator had before been elsewhere domiciled, we should be bound to consider him domiciled in Alabama, from the mere fact of finding him there. SS 377. Residence as evidence of domicile. It seldom happens, however, that the only criterion presented is the naked fact of presence at a place. Such presence usually appears under circumstances which show it to be more or less habitual and continuous, in which case it rises to the degree of residence. Dicey I has defined residence as habitual physical presence in a place or country, which definition, although not entirely correct, is approximately so, and sufficiently so for the present purpose. Thus understood, residence corresponds with the assidua habitatio or conversatio assidua of the civilians. It is laid down in many cases that residence is prima facie evidence of domicile, or, in other words, that the fact that a man is habitually and continuously present at a place is evidence that he intends to remain there permanently. But beyond this it is difficult to deduce any general principle from the decided cases, or from the reasoning by which they are supported. It is apparent that little importance can be attached to residence, if at the time to which the inquiry concerning domicile is directed, residence has just begun, or if it is under circumstances which are in themselves equivocal, or which tend to show animus revertendi, as in the case of a public officer, an ambassador or a consul, a soldier, an exile or a prisoner, or the like, or in the case of a married man who, being previously domiciled elsewhere, comes to a country without his wife and family, and at the time inquired about has spent but a short time there, boarding at hotels, either without any apparent business, or with business of short or doubtful duration. On the other hand, if residence is long continued and is accompanied by other circumstances indicating intention to remain permanently, it is of great weight in determining the question of animus menendi. This is no more than saying that residence is by itself only a single fact, which may or may not indicate animus menendi, according to circumstances. And this is substantially all that can be said of it, for it will be found that whenever particular stress has been laid upon residence, it has been either because it was long continued or because it was accompanied by other circumstances which tended to show animus menendi. SS 378, ID Wayne, J, and Ennis v. Smith. In some cases, strong expressions have been used with regard to residence. In Kosciuszko's case, Wayne, J used language which, perhaps, states the effect of residence too strongly, but what amount of proof is necessary to change a domicile of origin into a prima facie domicile of choice? It is residence elsewhere, or where a person lives out of the domicile of origin. That repels the presumption of its continuance, and casts upon him who denies the domicile of choice the burden of disproving it. Where a person lives is taken prima facie to be his domicile until other facts establish the contrary. It is difficult to lay down any rule under which every instance of residence could be brought, which may make a domicile of choice. But there must be to constitute an actual residence in the place, with the intention that it is to be a principal and permanent residence. That intention may be inferred from the circumstances or condition in which a person may be as to the domicile of his origin, or from the seat of his fortune, his family, and pursuits of life. A removal which does not contemplate an absence from the former domicile for an indefinite and uncertain time is not a change of it. But when there is a removal, unless it can be shown or inferred from circumstances that it was for some particular purpose, expected to be only of a temporary nature, or in the exercise of some particular profession, office, or calling, it does change the domicile. The result is that the place of residence is prima facie the domicile, unless there be some motive for that residence not inconsistent with a clearly established intention to retain a permanent residence in another place. But it must be observed that in this case other facts besides residence tended to show animus menendi. Kosciuszko had resided 19 years in France under circumstances and with declarations showing, on the one hand, his abandonment of his domicile of origin, and, on the other, his intention to remain in France permanently, or at least until the happening of an improbable event. SS 379, ID, residence by itself equivocal. But, on the other hand, in Isham v. Gibbons, it was held that naked residence amounts to nothing unless accompanied with evidence of intention, and in Jop v. Wood, it was said to be at least equivocal. In the latter case, Turner, L. J. said, although residence may be decisive as to the factum, it cannot, when looked at as to the animus, be regarded otherwise than as an equivocal act. The mere fact of a man residing in a place different from that in which he has been before domicile, even although his residence there may be long continuing, does not of necessity show that he has elected that place as his permanent and abiding home. He may have taken up and continued his residence there for some special purpose, or he may have elected to make the place his temporary home. But domicile, although in some of the cases spoken of as a home, imports an abiding and permanent home, and not a mere temporary one. SS 380, ID, Sir Herbert Jenner in De Bonneville v. De Bonneville. In De Bonneville v. De Bonneville, Sir Herbert Jenner said, I apprehend that it being prima facie evidence only, that where a person resides, there he is domiciled, it is necessary to see what was the domicile of origin of the party. Having first ascertained the domicile of origin, that domicile prevails till the party shall have acquired another, with an intention of abandoning the original domicile. That has been the rule since the case of Somerville v. Somerville. Another principle is that the acquisition of a domicile does not simply depend upon the residence of the party. The fact of residence must be accompanied by an intention of permanently residing in the new domicile, and of abandoning the former. In other words, the change of domicile must be manifested, animo et facto, by the fact of residence and the intention to abandon. A third principle is that the domicile of origin having been abandoned, and a new domicile acquired, the new domicile may be abandoned and a third domicile acquired. Again, the presumption of law being that the domicile of origin subsists until a change of domicile is proved, the onus of proving the change is on the party alleging it, and this onus is not discharged by merely proving residence in another place, which is not inconsistent with an intention to return to the original domicile, for the change must be demonstrated by fact and intention. The rule laid down by Lord Alvanley in Somerville v. Somerville, although his language is somewhat obscure, would seem to mean that clear proof must be made of abandonment of domicile of origin before any value can be attached to residence. SS 381, ID, Lord Westbury in Bell v. Kennedy and Sir John Nishall in Moore v. Darrell in Bell v. Kennedy, Lord Westbury used language in marked contrast with that of Wayne, J., above quoted. Lord Westbury said, although residence may be some small prima facie proof of domicile, it is by no means to be inferred from the fact of residence that domicile results, even although you do not find that the party had any other residence in existence or in contemplation. In this case, there was sufficient proof of abandonment of domicile of origin. But it also appeared that residence was in pursuance of a contingent animus maenendi. In Moore v. Darrow and Budd, Sir John Nishaw said, cases of domicile do not depend upon residence alone, but on a consideration of all the circumstances of each particular case. SS 382, length of residence or time. As the value of residence as evidence of intention depends largely upon the length and the manner of the residence, it is proper to consider these elements somewhat in detail. And, first, as to length of residence or time. Length of residence as a substitute for intention has already been considered in its appropriate place. It is proposed now to discuss it as evidence of intention. If a man leaves his domicile of origin and going into another country dwells there for a considerable length of time, for 10, 20, or 30 years, it needs no authority for saying that, in the absence of explanatory evidence, he will be presumed to intend to remain there permanently. Great weight has therefore been attached by the authorities to length of residence as evidence of animus maenendi, not only where it is unexplained and uncontradicted by other facts, but also in many cases where it is contradicted by facts which would otherwise be taken as indicating animus revertendi. But if the purpose of residence, however long, appears to be consistent with animus revertendi, the presumption of animus maenendi fails, and the stronger presumption of the continuance of the former domicile prevails, and, if fortiori, if sufficient evidence of animus revertendi appear, the presumption from time, of course, fails. Length of time is, therefore, strong evidence of intention, but by no means conclusive. SS 383, ID, Roman law and continental jurists. This criterion was so conspicuous as to call forth a declaration concerning it in the Roman law, namely, in the case of the student, concerning whom it was declared, by the letter of Hadrian, that he was not to be supposed to be domiciled at the place of his studies, unless, 10 years having elapsed, he had set up for himself a habitation there. Concerning the precise meaning and effect of this provision, there has been much discussion. Some of the civilians, among whom were Accursius and Baldus, apparently holding that residence in a place for 10 years created a legal presumption of domicile there, while others, including Alciatus, Mascartus, Menachius, Xandrus, Burgundus, Molonius, and, apparently, Bartolus, held that, while decennial residence was evidence of the establishment of domicile, it was not conclusive, but was to be left, together with all the other facts of the case, to the discretion of the judge to determine according to the condition and quality of the person and the place. SS 384, ID. Most of the civilians also took the position that, even in the case of the student, a domicile might be acquired without decennial residence. Burgundus says, Nec ipsi qui studium causa aliquo loco morenter, domicilium ibi habere credenter, nisi decem annis transactis eo loco sit sibi constituere, sed hoc intellige, redubia, ut puta quadax orum ibi duxerit, possessions emerit, professionum adeptissent. Aliaquin quadis de contraria voluntate constat, descend nali spatio domicilium non constituere. Idioque mercenarius, studiosus, mercator, quamdiu animum redundi habent, domicilium acquire non passant, animum viro redundi haber non videnter, qui transportatis bonus, qui in patria habent, alio domicilium transferent, sicut nec ille, qui in alia regiani digens, bona ibi emit, privalgem civitatis in petrat, uxorum ducit, decenniae spatio habitat, sed hoc ultimum in scholastico non aliter capindum erit, quam si aliquo alio signo perseverandi animum demonstrat. Quandiu enim lice in patrium meditare reditum, et absoluta studerum periodo remigrer vel, nullo temporis spatio domicilium constituiter. Domicilium ergo vel solo momento figi potus, si aperit de voluntate qui ex conjecturis non inet probabit. Corvinus says, nec etiam sola habitatio per se, etiansi sit longissimi temporis, domicilium constituit, qui tamen per decent annos alicubi morator, presumitur ibi domicilium allegis et incola existinitur, nisi de occasion temporaria et animo revertendi ad pristinum locum constet. Grotius, in an opinion quoted by Henry from the Holland Consultation, argues, neither, again, is it any objection quod decenio quaeritur domicilium, since it does not thence follow quod minor tempor non quaeritur, sed quod in dubio decennium per se sufficit ad probandum domicilium. Alia qui si de voluntate aperi, vel uno momento domicilium constitutum intelligitur. D. Argenter remarks, justa presumptio est de eo qui todos decent annos alici desedit, nam nulla tempora domicilium constituent alia cogitanti. Savigny says, the 10 years are indeed only a presumption of a purpose of constant residence. SS 385. ID. It is clear, therefore, that, on the one hand, whatever importance may have been attached to decennial residence, the presumption arising from it was not a conclusive presumption of law, but one of fact merely, which gave way to other facts tending to show animus revertendi, and, on the other, 10 years' residence was not necessary for the establishment of domicile if other facts showed the requisite animus maenendi. SS 386. ID. Lord Stawell in the Harmony. Lord Stawell, in a celebrated passage in the case of the Harmony, spoke thus as to the effect of time. Of the few principles that can be laid down generally, I may venture to hold that time is the grand ingredient in constituting domicile. I think that hardly enough is attributed to its effects. In most cases it is unavoidably conclusive. It is not unfrequently said that if a person comes only for a special purpose that shall not fix a domicile, this is not to be taken in an unqualified latitude, and without some respect had to the time which such a purpose may or shall occupy. For if the purpose be of a nature that may probably, or does actually, detain the person for a great length of time, I cannot but think that a general residence might grow upon the special purpose. A special purpose may lead a man to a country where it shall detain him the whole of his life. A man comes here to follow a lawsuit, it may happen, and indeed is often used as a ground of vulgar and unfounded reproach on the laws of this country, that it may last as long as himself. Some suits are famous in our judicial history for having even outlived generations of suitors. I cannot but think that against such a long residence the plea of an original special purpose could not be averred. It must be inferred, in such a case, that other purposes forced themselves upon him, and mixed themselves with his original design, and impressed upon him the character of the country where he resided. Suppose a man comes into a belligerent country at or before the beginning of a war. It is certainly reasonable not to bind him too soon to an acquired character, and to allow him a fair time to disengage himself. But if he continues to reside during a good part of the war, contributing, by payment of taxes and other means, to the strength of that country, I am of opinion that he could not plead his special purpose with any effect against the rights of hostility. If he could, there would be no sufficient guard against the fraud and abuses of masked, pretended, original, and sole purposes of a long continued residence. There is a time which will estop such a plea. No rule can fix the time a priori, but such a time there must be. In proof of the efficacy of mere time, it is not impertinent to remark that the same quantity of business, which would not fix a domicile in a certain space of time, would nevertheless have that effect if distributed over a larger space of time. Suppose an American comes to Europe with 6 contemporary cargoes, of which he had the present care and management, meaning to return to America immediately. They would form a different case from that of the same American coming to any particular country of Europe with 1 cargo, and fixing himself there to receive 5 remaining cargoes, 1 in each year successively. I repeat that time is the great agent in this matter. It is to be taken in a compound ratio of the time and the occupation, with a great preponderance on the article of time. Be the occupation what it may, it cannot happen, but with few exceptions, that mere length of time shall not constitute domicile. SS 387. ID. Criticism of Lord Stawell's remarks. These remarks have been often quoted, and in some cases adopted and to some extent followed. But it must be borne in mind that they were uttered in a case involving national character in time of war, and that the principles laid down in this class of cases must be used with great caution in cases involving the general doctrine of domicile. The laws of nations guard with great jealousy the right of capture by belligerents, both because prize cases are for the most part decided in the courts of the belligerents themselves, and because by capture commercial nations are brought more easily to terms, and thus fighting is abridged and life and property are saved. It is well to remember also that Lord Stawell leaned very strongly in favor of the rights of captives, and therefore we may naturally expect to find his views somewhat tinctured by his prejudices. His remarks concerning the lawsuit as applied to the general subject of domicile clearly are not sound, nor are those concerning mercantile venture. These illustrations seem to have been chosen with singular misfortune. SS 388 ID. If time is conclusive evidence of domicile, what length of time? It is pertinently asked by Sir John Michell in Stanley v. Burns, if time is conclusive, where shall the line be drawn? It is impossible to fix any period, as Lord Stawell himself admits. If a man goes to England for the purpose of conducting a lawsuit which actually requires, for example, but 1 year, has he gained a domicile? If he has, clearly it is not because of length of residence. If he has not, would he have gained a domicile if the suit had occupied 5, 10, 25, or 50 years? If 5 years' time is not sufficient, what length of time would be? The civilians speak, as we have seen, with no uncertain sound upon this subject, and declare that no length of time is sufficient if there be an intention to return. SS 389 ID. Dr. Lushington in Hodgson v. de Beauchesney. A much more reasonable doctrine is that which has generally been acted upon in the cases, and which has been set forth with great clearness and force by Dr. Lushington in Hodgson v. de Beauchesney and Kindersley v. C. in Cockrell v. Cockrell. The former said, speaking for the Privy Council, "We concur in opinion that great weight is to be attributed to length of residence, but we think that other matters must be taken into consideration. We think that length of residence, according to its time and circumstances, raises the presumption of intention to acquire domicile. The residence may be such, so long and so continuous, as to raise a presumption nearly, if not quite, amounting to a presumption juris et de jure, a presumption not to be rebutted by declarations of intention or otherwise than by actual removal. Such was the case of Stanley v. Burns. The foundation of that decision in this respect was that a Portuguese domicile had been acquired by previous residents and facts, and that mere declarations of intention to return could not be sufficient to prove an intention not to acquire a Portuguese domicile. In short, length of residence per se raises a presumption of intention to abandon a former domicile, but a presumption which may, according to circumstances, be rebutted. It would be a dangerous doctrine to hold that mere residence, apart from the consideration of circumstances, constitutes a change of domicile. A question which no one could settle would immediately arise, namely, what length of residence should produce such consequence. It is evident that time alone cannot be the only criterion. There are many cases in which a very short residence would constitute domicile, as in the case of an Emmy Grant who, having wound up all his affairs in the country of his origin, departs with his wife and family to a foreign land and settles there. In a case like that, a residence for a very brief period would work a change of domicile. Take a contrary case, where a man for business, or pleasure, or mere love of change, is long resident abroad, occasionally returning to the country of his origin, or maintaining all his natural connections with that country. The time of residence would not, to the same extent or in the same degree, be proof of a change of domicile. We concur, therefore, in the doctrine held in many previous cases, that to constitute a change of domicile, there must be residence, and also an intention to change. SS 390 ID. Kindersley v. C. in Cockrell v. Cockrell. Kindersley v. C. in the case above mentioned, says length of time is considered one of the criteria, or one of the indicia from which the intention to acquire a new domicile is to be inferred, and it is considered a very material ingredient in the consideration of the question. In the case of the harmony, Lord Stawell says, of the few principles that are laid down generally, I may venture to hold that time is the grand ingredient in constituting domicile. Some foreign jurists have suggested, if they have not actually laid it down, that a period of 10 years ought of itself to be a sufficient indication of the intention to acquire a new domicile. But certainly that is not the view of the law that has been adopted by English jurists, nor do I think it is the rule adopted by jurists generally. and I think it is impossible to lay down any precise period which per se is to constitute domicile. At the same time, if a man goes to another country and continues to reside there for a considerable period, as in this case for 10 years, without saying that a residence of 10 years is necessary, or that 10 years is the period sufficient, still the fact of his residing there for 10 years is a very strong indication of his intention to establish his home and his domicile in that place. SS 391, ID, Poland, J. and Hewlett v. Hewlett. But the doctrine has been nowhere better stated than by Poland, J. and Hewlett v. Hewlett. One may remain for a long time in a place without having it become his domicile, and be all the while a mere temporary sojourn. But where one's stay in a place is short, and then he returns to his former home, it affords some presumption or evidence that he went there for a temporary purpose, with no intent to remain, while if his stay or residence is protracted and long continued, it furnishes a corresponding presumption that he designed to remain from the beginning. Other facts and evidence may overcome the presumption in either case, and show that the short stay was of a legally permanent character, and that the longer one was but a mere absence from home, working no legal change of residence. But this by no means prevents the permanence and duration of the stay from being admissible, and important evidence on the question. Whenever the intent or mental purpose of a person becomes a question to be proved, his acts and conduct are admissible evidence, and often the best and only evidence of it, and his acts and conduct subsequent to the point of time when such intention is to be shown, are more satisfactory than those which precede or coexist with it. SS 392, ID, Story, J. in the Anne Green. In a prize case, Story, J. used this language as to domicile. It is undoubtedly true that length of time, connected with other circumstances, may go very far to constitute a domicile. Time, says Sir William Scott, is the grand ingredient in constituting domicile. I think that hardly enough is attributed to its effects. In most cases it is unavoidably conclusive. Upon a residence, therefore, for temporary purposes, there may be engrafted all the effects of permanent settlement, if it be continued for a great length of time and be attended with conduct which demonstrates that new views and new connections have supervened upon the original purposes. But, on the other hand, mere length of time cannot of itself be decisive, where the purpose is clearly proved to have been temporary and still continues so, without any enlargement of views, and even the shortest residence, with a design of permanent settlement, stamps the party with the national character. It has already been pointed out that the American courts are much more disposed than those of Great Britain to place the doctrine of national character upon the broad basis of domicile. SS 393, ID, Cases in which long residence was held insufficient to change domicile. Seer Garangeau's case, White v. Brown. It may be well now to consider a few of the cases in which time has been either relied upon or rejected as determining the question of intention. Allusion has already been made to the case of Seer Garangeau, reported by Denizart, in which it was decided that residence of 64 years was not sufficient to show the requisite intention, in the absence of any act declarative of his will, his presence being in the performance of the duties of an office from which he was removable. White v. Brown was the case of one who, having his domicile of origin in Pennsylvania, was, by reason of his adherence to the British king in our revolutionary struggle, forced to leave his native state in 1776. He went to England and remained there 48 years, until his death. There were declarations and acts tending both ways, and Grier, J. left the question of his domicile to the jury, charging them, inter alia, did he go to England with the intention of making it his home? If not, did he at any time while there change his intention, so that the animus may then be concurred with the act of inhabitancy so as to constitute a change of domicile? The leading fact that he spent the greater part of his life in England and died there raises a violent presumption that his intention corresponded with his acts. But as I have before said, in questions of succession, even 48 years spent in a foreign country may possibly be accounted for, and the inference drawn from length of time rebutted. The jury having found in favor of his American domicile, upon a motion for a new trial, the court, expressing satisfaction with their finding, refused to set it aside. SS 394, ID, in Recaptiviel, Jop v. Wood. Emery Capdevielle was the case of a Frenchman who had resided and engaged in business in England for 29 years, but this was considered by a majority of the Court of Exchequer to be overborne by other evidence, principally declarations, which showed animus revertendi. In Jop v. Wood, a domiciled Scotchman went to India and, engaging in private business, remained there 25 years, with the exception of 1 year which he spent in Scotland. He purchased land in India as a necessary incident to his business, and also a dwelling house in Calcutta, and described himself in a will and in other instruments of Calcutta. But this evidence was not allowed to weigh against his retention and improvement of landed estate in Scotland, and his frequent and continued declarations of his intention to return to that country, and his domicile of origin was held by Lord Romilly, M.R., and by Knight Bruce and Turner, L.J.J., on appeal not to have been changed, considerable weight being given to the fact that his domicile of origin was Scotch. In this case, Turner, L.J., incidentally expressed his opinion that 7 years' residence in India would have been too short to have operated to change the domicile in the absence of any other evidence of intention to change it. It has been suggested, however, that this case stands upon peculiar grounds, in view of the well-known custom of Englishmen and Scotchmen who go to India for the express purpose of making money and returning as soon as possible. SS 395, ID, Hodgson v. de Beauchesne, Capdevielle v. Capdevielle. Perhaps in no case has the effective time been more thoroughly discussed than in Hodgson v. de Beauchesne, decided by the Privy Council, and that case has come to be looked upon as a leading one upon the subject. Hodgson, a colonel in the East India Service, whose domicile of origin was English, having married a French wife and being on furlough, in deference to the wishes of his wife, went to Paris, where he took lodgings and continued to reside 23 years, until his death. Upon the death of his wife he purchased a burial place in France, and had inscribed upon it Famille Hodgson, and there was some evidence that he expressed an intention to be buried there. There was also other evidence, of, however, no very strong character, tending to show permanent residence in France. During his residence in France he was appointed a Major General in Her Majesty's service, limited to India, and subsequently promoted to a Lieutenant Generalship. His property, with the exception of his household furniture, was all in England, where he kept his accounts and from time to time invested his savings. He made several wills in English form, and was married to his second wife in the chapel of the British ambassador, when he declared his domicile to be English. He never applied to the French government for authorization to become domiciled in France, and expressed great indignation at being called upon to serve in the National Guard. Under these circumstances, it was held that he did not acquire domicile in France. It was admitted that great weight is to be attributed to length of residence, and that length of residence per se raises a presumption of intention, but it was held that the circumstances of this case were sufficient to rebut such presumption, great weight being attached to General Hodgson's military status, which was here looked upon as an evidence of animus non menendi rather than as a bar to the acquisition of domicile in a foreign country. In Capdevielle v. Capdevielle, Malins v. C. held, in the case of one who was French by origin, that 20 years' residence in England, engaging in trade, purchase of real estate, building of a dwelling house at an expense of £5,000, and burial of his wife and child there were insufficient to show intention of permanent residence, it appearing, from his declarations mainly, that his views were uncertain and his mind vacillating. SS 396, ID, Gillies v. Gillies, West Case, Monroe v. Monroe. In Gillies v. Gillies, in the Irish Court of Probate and Matrimonial Causes, Warren, J., while admitting that long residence is calculated to create a strong impression in favor of the acquisition of a new domicile, and sufficient prima facie to show such acquisition, held, in the case of one whose domicile of origin was Irish, that residence abroad for health, which was consistent with the hope of a change which would enable him to return and reside in Ireland, was not sufficient to work a change of domicile, even though it continued 19 years in France, and, during the last 12 years, in a purchased house in that country. In this case, the person whose domicile was in question had, before anticipation of suit, executed 4 wills, in which he described himself as domiciled in Ireland, and the court held that this, in connection with his own testimony that health was the motive for his residence abroad, rebutted the presumption flowing from long residence in France and the purchase of a house at Pau. In West's case, Sir C. Cresswell held residence by an Englishman for 14 years in France after a previous residence out of England for 11 years, insufficient evidence to show that the testator had renounced his domicile of origin and acquired a French domicile, there being opposed to length of residence other facts and declarations showing animus revertendi. In Munro v. Munro, Lord Cottenham, while considering residence of 7 years by a Scotchman in England as important evidence of intention to reside there permanently, held it to be overborne by other proofs in the case, the principal of which were his ownership of an entailed estate in Scotland, his repeated declarations in his correspondence of his intention to return, his preparations for his return by giving directions for the fitting up of his family residence, accompanied by the shipment of large quantities of furniture, and his actual return after the time to which the inquiry concerning his domicile was directed. Lord Brougham concurred. SS 397. ID. Cases in which length of residence was held sufficient to change domicile. Stanley v. Burns, Anderson v. Lanneville, Attorney General v. Kent, Brunel v. Brunel, Hood's estate. On the other hand, in the following cases the change of domicile was held to have taken place. In Stanley v. Burns, Sir John Nishaw looked upon 56 years' residence of an Englishman in Portugal, coupled with marriage and naturalization, as strong evidence of his intention to renounce his domicile of origin and acquire a domicile in the latter country. In Anderson v. Lanneville, the Privy Council, Dr. Lushington delivering the opinion, held with respect to one whose domicile of origin was Irish, but who had resided in England for 42 years, the domicile of origin was lost, and an English domicile acquired by long residence in England. In Attorney General v. Kent, the Court of Exchequer held domiciled in England a Portuguese who had resided in England 39 years, during the first 15 of which he was engaged in trade, and this conclusion was reached in spite of his declaration in his will that he had always intended returning to his own country, the declaration being obviously made for the purpose of avoiding legacy duty, liability to which was the question involved in the case. The court, in reaching its conclusion, seems to have relied mainly, if not entirely, upon the fact of long-continued and unexplained residence. In Brunel v. Brunel, the domicile of a Frenchman who had resided 35 years in England, had married an English wife, had purchased a family grave in an English cemetery, and had taken various long leases of real estate in London, was held to be English in spite of his declaration that he might return to France, and his refusal to become a naturalized British subject or to give up his citizenship in Paris. The grounds of his decision were not fully stated by Bacon v. C., but it is apparent that length of residence was one of the main determining facts. In Hood's estate, the testator, whose domicile of origin was Pennsylvanian, had resided and engaged in trade in Cuba for upwards of 30 years, occasionally visiting this country for business and pleasure. Being originally a Protestant, he professed the Roman Catholic religion, and obtained letters of naturalization from the Spanish government. He purchased several sugar plantations in Cuba and owned other property there, although, on the other hand, he owned property, real and personal, and was interested in a mercantile house in this country, and had expressed a desire to be buried here. Under these circumstances, the Supreme Court of Pennsylvania held his domicile to be in Cuba, giving considerable weight to his long residence on that island. SS 397A. ID. Williamson v. Parisian, Dowsett v. Geocagan, Haldane v. Eckford, Allardus v. Onslow, Lyle v. Patton. In Williamson v. Parisian, the plaintiff, Scotch by birth, came to New York during the Revolutionary War, and there, in 1780, married an American wife. In 1784, he deserted her and went to the West Indies, where he remained, with the exception of a visit to New York in 1792, until 1813, during which year he again returned and began proceedings in divorce. Upon these facts, Kent, C.H., held that a presumption of change of domicile arose, which it was for the plaintiff to rebut, the facts concerning his residence being in his possession, and the bill was dismissed for want of jurisdiction. Plaintiff's New York domicile prior to his departure in 1784 was assumed. In Dowsett v. Georg Hagen, the testator, a Frenchman by birth and a Catholic, resided and engaged in business in England 27 years, married successively 2 English Protestant women, and had his children brought up in the Protestant religion. On the other hand, were his refusal to be naturalized, his frequent returns to France, and his declaration of his intention to finally return to and reside in that country as soon as he had made a fortune. Malins v.C. held his domicile to be English, and was affirmed by Jessel M.R. and James and Brett L.J.J., great stress being laid on the fact of long residence as evidence of intention to reside permanently. In Haldane v. Eckford, residence for a great number of years was, inter alia, relied upon by James v.C. for holding one whose domicile of origin was Scotch, domiciled in Jersey, and in Allardis v. Onslow, Kindersley v.C. held one whose domicile of origin was also Scotch, domiciled in India, upon the fact of 20 years' residence in the latter country as a coffee planter, and his description of himself in his will as so resident. In Lyall v. Patton, Kindersley v.C. again held to the same effect under almost precisely similar circumstances. SS 398, Heidi, Ennis v. Smith, King v. Foxwell, Bremer v. Freeman. Ennis v. Smith has already been referred to. It was there held by the Supreme Court of the United States that the domicile of Kosciuszko was, at the time of his death in 1817, French. The facts of the life of the Polish patriot do not appear to have been very fully before the court, but of the proofs which were before it, particular weight appears to have been attached to the fact of residence of 17 or 18 years in France, which the court considered sufficient to rebut the presumption of continuance of domicile of origin, and to create the contrary presumption of animus menendi, to the extent, at least, of casting the burden of proof upon the person alleging that the residence was for a temporary purpose. Similar to the doctrine of Ennis v. Smith was that of Jessel M.R. and King v. Foxwell, in which the testator, an Englishman, emigrated to the state of New York and there resided 15 years, engaging in business as a shoemaker and becoming a naturalized citizen of the United States. He was held to have acquired a domicile in New York, the master of the rolls saying, "You must therefore show permanent residence in a new country." Neither of these is a simple fact, for I take it that all these questions of status involve a good deal more than can be seen by the eye. Residence is not eating, drinking, and sleeping at a particular house. All these things may be done for years, while a person is traveling. On the other hand, a person may have a residence, and yet not visit it for a number of years. That may be his only residence. He may have no other home. It is, therefore, difficult to say what residence is, but that is what the law requires. Again, what is the meaning of permanent residence? That is a question which cannot be decided by mere length of time. The answer to it must involve the consideration of the intention of the person. That being the state of the law, did this shoemaker intend to reside permanently in the United States? There can be no question as to residence. He had a shop and house in Syracuse for 15 years, and during those years he had no other place of abode. Then did he reside there permanently, or was it the intention on his part to reside for a limited period only? If you show that a man resides in one place for a length of time, the inference is that he intends to reside there permanently, unless there is something to rebut it. And here, therefore, the testator, having lived in the United States for 15 years, must be taken to have resided there permanently, unless some evidence is produced to the contrary. In Bremer v. Freeman, the testatrix, an English woman by birth, resided in Paris for 15 years without any business or occupation and without quitting it, taking apartments on leases and furnishing them herself, and making occasional declarations that she would never return to England, and that she wished to be buried near her sister in the cemetery of Père Lachaise. Her domicile was held by the Privy Council to be French, notwithstanding the fact that she had never obtained authorization from the French government to fix her domicile in France. SS 399, ID, Cockrell v. Cockrell, Attorney General v. Fitzgerald, Weston v. Weston, Shelton v. Tiffin, Easterly v. Goodwin, Hawley's case. Cockrell v. Cockrell was the case of an English officer in the Navy upon half pay, who went to India and engaged in a very lucrative business. He married there, had children born, and continued there in business for 10 years until his death, receiving half pay and applying from time to time for fresh leaves of absence. Kindersley v. C. held him to be domiciled in India, laying great stress upon the fact of his long residence, remarking, "The fact of his residing there for 10 years is a very strong indication of his intention to establish his home and his domicile in that place." In Attorney General v. Fitzgerald, the same vice-chancellor considered residence for 9 years in a leased house in England sufficient evidence of a change of domicile by one whose domicile of origin was Irish, but who had resided for 10 years in India. The facts of this case are, however, but meagerly reported. In Weston v. Weston W., whose domicile of origin does not appear, but who had resided 16 years in New York, and who their own land, the ownership of which he retained up to the time of his death, departed from that state, leaving behind him his wife, and went to Ohio, where he resided 10 years and died. His wife continued to reside in New York up to the time of his death. Under these circumstances, the Supreme Court of New York held him domiciled at the time of his death in Ohio, Spencer J. remarking his long residence in Ohio separated from his wife, and the absence of all proof that he intended to return to this state are decisive circumstances to show that there was a change of domicile, and he must be regarded as an inhabitant of the state of Ohio. In Shelton v. Tiffin, the Supreme Court of the United States considered residence of 2 years, coupled with the purchase and cultivation of a plantation, as raising a strong presumption of change of domicile from one state to another. In Easterly U. Goodwin, where he went to California in 1850 on business and resided there at intervals until 1858, the Supreme Court of Connecticut, speaking through Park J., said, "No doubt the length of time the plaintiff remained in California and his exercise of the elective franchise there were important facts upon the question of citizenship, and unless controlled by evidence of a superior character, would have been sufficient to warrant the court in finding that he was a citizen of that state." In Hawley S. case, a person of Irish birth came to this country when he was 13 years of age, and remained here until he was 23, when he returned to Ireland to see his father, who was ill, and remained there, following his calling as a mechanic, for 7 years, when he returned to this country and attempted to be naturalized. Dolly, first judge, who in this and other cases put the residence required by the naturalization laws upon the ground of domicile, held that he had lost his residence in this country, although at the time of leaving he had expressed his intention to return, and had previous to leaving made a formal declaration of intention to become a citizen. SS 400 ID, result of the decisions. And so cases might be multiplied indefinitely, but enough have been cited to show that the real ratio of the decisions is that long continued residence, although not conclusive, creates a strong presumption of intention to reside permanently, and shifts the burden of proof upon him who alleges otherwise, which burden may, however, be discharged by proof of superior facts showing animus revertendi.